CV, which is quite rich. As a JO, you've largely been a JO. Now, the only thing you need to do now is to demonstrate, because there are quite a number of you who have applied, and there are others, of course, who are equally good. The positions are few, so it's incumbent upon you to show that you rank higher than the others. It's upon you to, the burden of proof is on you. So you just need to pick for me two attributes, and also you back it up with experience, where you think you've made significant impact that will be able to demonstrate that even as we retire to make a decision on who should be picked, that without doubt that at least we must pick you. And in doing so, please avoid being general, because the mistake many people when they are being interviewed is they say the general things, which everybody should have anyway, for them to be a JO or to be a legal practitioner. So just distinguish yourself by saying what are these key attributes backed by experience, personal experience.
Okay, thank you, Commissioner. I'll start by saying, as I've said, my name is Francis Kyambia. I'm a Chief Magistrate based in Embu currently. And before I joined the judiciary, I practiced as an advocate in Mombasa for a period of 4 years with the firm of Tribe Advocates. Then in 2006, I joined the judiciary and I was posted in Bungoma. I worked in Bungoma, Eldoret, Sirisia, Mombasa, and now I'm Mandara, and now I'm currently in Embu. Just to highlight some of my key achievements in the station I've worked, like when I was in Bungoma Law Court, I was given the responsibility by the head of station to be in charge of the civil registry. As we all know, by then there were so many problems in the judiciary, and some of the civil, in terms of when we went to the civil registries, there were problems in terms of the dates, in terms of the disappearance of the files, and I managed, under the leadership of the head of station, Honorable Justice Nyungu, to streamline that registry. And I was able even to make sure that the operations of the registry were going on smoothly, in terms of even the dates and the disappearance of the files, and even managed to have files to have dates. No files was going back to the registry without a date. We streamlined the execution process where there was a big problem, and we managed to, in terms of revenue, to increase the revenue collection in that registry. I moved to Eldoret Law Courts. At Eldoret Law Courts, I was also given the responsibility also to oversee the civil registry. Again, I was able to streamline that registry. And I also went to Sirisia Law Courts. In Sirisia Law Courts, I was the head of station. And by then, we had not, the performance in the judiciary had not been institutionalized as it is today. But together with my colleague, we were able to measure ourselves at that time. We would, at the end of the month, get to measure ourselves, the matters we have concluded, the matters which are pending. It was not scientific measurement like we are having today. Then from there, I moved to Mombasa. And in Mombasa, I can say I was very instrumental in terms of clearance of the case backlog. There was a lot of case backlog in Mombasa, and I was in the civil registry, and we managed to clear a lot of case backlog. I can say that in my duty in Mombasa, my tour of duty in Mombasa, I was fitted twice by the Mombasa Law Society and also by the stakeholders. Then I moved to Mandara Law Courts. Mandara Law Courts, I was not there for long. I was there for 1 year and around 9 months. And for the period I was there, I managed to, as a team leader, I was the head of station. I managed to bring my colleagues together, and I would give them duties in terms of adding dockets Like we had people heading the criminal registry. We had people heading, no, we have, Makandara is a criminal court, but we had 4 registries. Out of those 4 registries, we had the criminal registry dealing with the penal matters. We had miscellaneous, petty, and traffic. And I managed to get all my colleagues to head all those sections as a team. And we worked as a team during that period, and we managed to clear backlog. And I must state this, I went to Makandara when we were transiting from the COVID. We were transiting from the COVID, and I found that one of the things I found at that station is there was a, in terms of filing of returns, there was a problem because that is one of the court which was mostly affected by COVID, because it's a court which would be closed for 14 days. So there was that problem of filing of the returns. And actually, I remember the inaugural meeting of the Honorable the CJ with the head of stations. She questioned what is wrong with Makandara, and I managed to put my team together, and we managed to again the registrar automation. I had people to be trained, and we managed to bring our data together. And I can say, by the time I was leaving that station, the data was actually in order, and we were performing very well. I must also say that we had a shortage of space in Makandara, and I again to the Directorate of Building Services. We created a space in the court. We also, there was no parking. I mean, there was parking, but there was no shade for the parking, and notwithstanding the edge of that court, but we managed to come up with the a parking. Over and above that, in my course of duty, I've been very diligent in administration of justice in the courts where I've worked. I've demonstrated impartiality, and have the intellectual capacity to do justice. And my policy and my philosophy of law and as a judicial officer is that I am a person who is who revolves around the administration of justice with impartiality, not being guided by any other interest other by the interest of justice, and for that matter, social justice. Honorable Commissioner.
Okay, my final question now.
Yes.
Because you see, we are looking for a judge,
Yes.
who create an impact, particularly in resolution of disputes. Now, what is it that you think you'll be able to do, and that you've already done, that will ensure that even as you resolve those disputes, firstly, it's expeditious, but also you're able, the quality of the justice itself is also not compromised? Yeah. And in answering that question, give specific examples of matters that you've handled that you thought were challenging, but you handled them in an expeditious manner, and that the decisions that were ultimately delivered met, that standard of quality, the quality assurance.
Thank you, commissioners. I think I'll start by saying that when I was in the Makandara law courts, and just recently before I was moved, there was a demonstration going around across the country, and people were being arrested, brought to court. There was a lot of pressure on both the judicial officers and even the other stakeholders in the justice system. And one of the matters which was brought before me was the matter involving Maina Jenga, and it was brought there together with others. And it is a matter which attracted a lot of interest, and the advocates were so many who appeared in that matter. It was a battery of advocates. We are talking about over 10 advocates to address the court. There was also, on the part of the Director of Public Prosecution, they brought quite a number of prosecution counsels. And the issue was, they came for plea. The issue was the bond. The preliminary issues which are raised, they raised the issues about whether the Office of the Director of Public Prosecution is properly constituted, because by then the DPP had been appointed to another position and there was no substantive DPP. that was one of the issues, a preliminary issue which was raised. They also raised the issues of the charges, whether the charges were properly before the court. They also raised the issue of the violation of the rights of the suspects who had been brought to court then. And there was a lot of pressure, as I've said, and I managed to withstand that pressure. I made a preliminary rulings in that matter before they could go ahead and take plea. And even after taking plea, there was an application by the Director of Public Prosecution to oppose bond. And that is a matter which, because as I've said, there are so many advocates, and Mandara, for those who have worked there, like my colleague, Honorable Commissioner Olwande, it is a busy station, but I managed to deal with that matter, and at the same time, deal with also with my cost list, and I reserved my ruling to the following day, and I gave my ruling as it were. I can as well give another example, Commissioner, if you allow me. When I was in Mombasa, I handled terrorist matters, and one of the matters which I inherited from my predecessor who were there was a matter where some suspects had been arrested with some explosive. The allegation was they were found with explosives, and it's a matter which I found. I looked at the file. When I went there, I perused the file, and I found that it is a matter where there was a lot of public interest from the top, because when as I was looking at the file, I saw a communication from the office of the president then by Mr. Kinywa, and you know, when you see that such a kind of communication and you are handling the matter, you will feel like there's a lot of pressure and you can feel intimidated. But notwithstanding that, I managed to deal with that matter. I gave my judgment. I convicted one of the person who was accused. The other one I acquitted, and I think, and I did that expeditiously. Similarly, Commissioner, when
yeah, that's enough. At least you've, I think you've acquitted yourself.
Thank you.
All right, thank you.
Thank you. Thank you, my lady. Good afternoon once again.
Good afternoon to you, Your Honor.
Yes, I want to say here now that we practiced together in Mombasa.
Yeah.
And yes, I also worked in Mandara, and what you say about Mandara is indeed true. The area I want to engage you on is on civil law.
Yes.
Okay, before we get there, what do you understand by the term standard of proof?
The standard of proof is, I would say, I would distinguish. Let me just distinguish it, because the standard of proof and the burden. The standard of proof is the level of proof which is required in a particular case.
Thank you.
Yes.
That's enough.
Thank you.
So now, what is the standard of proof?
The standard of proof in traffic case, I would say that first, I'll start by...
Sorry, let me just qualify that. In a criminal, I mean not criminal, but where someone has been charged for a traffic offense.
Yes. In answering that, Commissioner, I'll start by saying that a traffic offense is an offense of strict liability. And when it comes to the standard, I mean the burden of proof.
No, standard. I'm asking about standard.
The standard is that of beyond reasonable doubt.
Okay.
Because it is
Okay.
Yes.
Now I want to give you a scenario, and then you tell me
Yes.
how you would resolve that scenario.
Yes.
So a matter has been brought before you,
Yes.
and you have a matter pending before you for an accident case for damages.
Me,
Sorry?
Just 1 minute. I'm not able to open. I don't know what's the problem. Yes. Okay.
Sorry about that.
Okay, thank you.
So you have a case before you where someone has sued for damages
Yes.
in connection to an accident.
Yes.
And the defense that the defendant has brought, now it's a civil case.
Yeah.
The defense that the defendant has brought is that he was acquitted in relation to the traffic case where the standard of proof is higher, as you have said, beyond reasonable doubt.
Yes.
So he says you ought not to find him liable. How would you resolve that case?
Thank you, Commissioner. My position is that a mere acquittal and a criminal in a traffic offense does not necessarily make the person who caused the accident not liable when it comes to traffic. I mean, when it comes to a civil matter.
Why is that?
Yeah. Because here you are talking about negligence. Yeah. The person might have been acquitted, but at the same time, he might have been negligent in the way he drove the vehicle. Let me put it that way. Yes.
Most probably, if it's an accident case, this person has probably been charged either with causing death or careless driving. There's an element of negligence in those two offenses.
Yes.
So why would you say that the fact that he was acquitted in the traffic case doesn't mean he is not culpable in terms of liability?
I'm saying that, Commissioner, because as I've said, the mere acquittal is not does not necessarily mean that the element of negligence is not there, in as much as the burden of, the standard of proof in the civil matters is on balance of probability. Yes.
So why would you say that these people were, one of the ingredients they were looking for in the careless driving or causing death is negligence, and they acquitted him?
Yes.
So why would you say that?
I'm saying that because one of the elements of causing death, it might not be negligence, it might be recklessness, but that one does not mean you are not negligent in the manner, the way you drove the vehicle.
Okay. Do you have any case law you can think of that is offering you that guidance?
I think as of now, I don't want to lie to the Commission that I have a case law in mind. But given the opportunity, I can, and of course, I do research, and I know it's an area where I can be able to go and research and be able to, of course, when I'm making my judgment, to be able to look at it.
Okay.
Yes.
Okay, thank you, my lady.
Thank you, Commissioner.
Yes. Now, you mentioned Mandara, and you said, I wrote to you and asked, what is the problem in Mandara? I think this panel would like to hear what is the problem of Mandara. Yes. What was so unique about Mandara? The corruption index in Mandara is higher than anything else. I remember we had to do even a memo, or is it guidelines on how to correct fines because of the corruption and the number of people being arrested, paying money around their bribes. What is the problem of Mandara?
Thank you, Honorable CJ. Let me start by saying, what happened is, it was not, you did not write to me. What happened, there was the first inaugural meeting with the head of stations. I was in Mandara, and we were looking at the data, and Mandara was nil. Because, and as I've said, one of the problems of that data was because of the court was being closed during the COVID-19, and no returns were being sent to the depot, as it were.
So the first problem was returns.
Returns.
DCRT, or whatever we call it, they were not filing it.
Yes.
What is the next problem? Because Mandara has been
the next problem is, Mandara is, and I want to say this with a lot of respect to the commissioners, that Mandara is a very unique court in the first instance. It is only one of the criminal courts in Kenya, and probably, I would say, in south of Sahara, which handles most of the criminal matters, and most of the people who come to Mandara, they are people from that part of the part of the city that is the Eastlands. And I would want to say that those are one of the most vulnerable people in our city, because you'll find all the people you'll find in that place, most of them are the poor people living in informal settlement.
Okay, so there are many poor people who cannot afford bail and board. What is the other problem? Because we have to move very fast.
Then the other problem is Mandara being what it is a court where you'll find, and I must say this without contradicting myself, that it is a court, and for those who have worked there will attest to it, is a court where there are so many brokers around. And I would say this, I managed to kind of, because it is only in Mandara where I managed to arrest advocates, people who pretended to be advocates. And I can say, as we are sitting, there are 3 cases which are pending in Mandara for people who have been masquerading as advocates. We managed to arrest them. We also managed to arrest brokers. There are some matters which are pending in that court of brokers, people arrested for of various reasons, they come and they lie to the members of the public that they can help them. And
so Law Society members are here, they can hear that there are masqueraders in Mandara who are masquerading as advocates, so they need to heighten their game there to have them nipped and working with the court. So I think for the interest of time, we'll move to the other areas that we want to hear you on. And I will take you to Article 26 of the Constitution in respect to the right to life. First of all, when does life begin?
Thank you.
And then, after that, you will answer under what circumstances of the Constitution is abortion allowed.
Thank you, Honorable CJ and the commissioners. Life begins at the conception. And when it comes to when abortion can be allowed, it is when the health of the mother is at risk. Then the abortion can be allowed.
That is one, two.
Yes. And I think probably even when the health of the unborn is also at risk, abortion can be allowed.
Are you sure about that?
Yeah. I'm not very sure.
Yeah.
Yes.
Okay. Yeah. Any other?
I think those are the one I can recall, Honorable CG.
Yes. You can refresh on that. We can move to arbitration.
Yes.
Under what circumstances does arbitration take place, and when can the court interfere with the arbitral award? Thank you,
Honorable CJ. An arbitration can take place where the parties have agreed that in case of any dispute which arises in either in a transaction, they would refer the matter to the arbitration. Then, once an award has been made by the arbitrator, the same under Section 35 of the Arbitration Act, the same can be set aside by the High Court. When, for instance, when the award was procured through maybe bribery, corruption, and all, it's against the public policy. Yeah.
Okay, thank you. Justice.
I just have two questions, or rather one. You're familiar with the Law Reform Act?
Yes, I'm familiar with the Law Reform
and
Act.
the Fatal Accidents Act?
Yes, I'm familiar.
Why was the Law Reform Act enacted?
Thank you, Commissioner, Judge. I think the Law Reform Act was enacted to take
purposes of accident cases. And
for purposes of accident cases, yes. It was enacted so that if somebody is, for instance, has been involved in an accident and he has died, then his estate or her estate can move the court to seek damages.
Okay.
Yes.
Okay, that's good. And the Fatal Accidents Act?
The Fatal Accident Act, again, was also enacted, and one of the objectives of the Fatal Accident Act is that, again, when somebody is involved in an accident and he has died, then his estate can seek damages for dependency.
Is it the estate or the dependents?
The dependents.
The dependents,
yes.
Okay. That is good. I can see you in your sample writings, you only included criminal judgment. Is it that you don't do civil matters?
Not necessarily, Your Lordship. What happened is I had previously applied for the position of the judge twice, and I brought judgments from Mombasa, which were mainly civil. But now, by the time this application, when the advertisement came, I had worked in Mandara, and I brought some of my recent decisions. I did not bring the older decisions which I had brought earlier on.
Okay.
Yes.
And I can see you have put there a bail ruling. Yeah.
Yes.
I want to ask you, what is your answer to these people who say that the Kenyan courts are unduly lenient on bail terms for rich people?
I think, Honorable Judge and Honorable Commissioners, I will start by saying that bail at bond is a constitutional right. It doesn't matter whether you are rich or you are poor. Everybody is entitled to bond, and actually it is supposed to be as a matter of right. They don't have to ask for it. So I don't think that criticism of the rich people and the poor, I don't think that criticism holds water, because all one has to consider is the circumstances of each and every case.
Thank you.
Thank you very much.
Thank you, Honorable CJ. Your Honor,
Yes.
Mr. Kyambia.
Yes, Commissioner, Judge.
Yes, now you've applied to be a judge of the High Court.
Yes.
The High Court, you will not be dealing with specifically you will not be restrained or confined to a particular area. You will deal with many cases. In fact, most likely, if you are posted to some places like Nairobi or Mombasa, the commercial towns, you will deal with a lot of civil and commercial matters.
Yes.
And one common practice is the issue of the process of injunction applications.
Yeah.
Of course, you're familiar with that.
I'm familiar with injunction.
We don't have any sample writing about injunctions, but you have dealt with them.
I've dealt with them quite a number of times.
And you know the principles.
I know the principles applicable.
Yes. Now, I want to just now to discuss briefly how many types of injunction orders do exist in law in Kenya or generally in the Commonwealth.
I think there is a prohibitory injunction.
Yes.
There's mandatory injunction.
Prohibitory, and just short definition.
Prohibitory injunction is an injunction where a party is prohibited from doing something.
Okay.
Then there's we also have mandatory injunction.
Yes.
Yes.
Uh-huh.
Then
Mandatory is to do what?
is to compel a
Okay.
party to do what is.
Another more complex one.
There's the more complex one, which actually I have, in the course of my career as a judicial officer, I've not dealt with. There's the Mareva injunction.
Yes. What is it about? In fact, I'm surprised you didn't do it in Mombasa.
I didn't do it in Mombasa, maybe because probably it did not come.
Even as a lawyer.
Okay.
What is it involved?
Your Lordship, I think for Mareva injunction, I have an idea, but I can't really express it now. I need to go and look at it. Yes.
Okay. And one last one. Do you know Anton Pila injunction?
Yes, I've heard of Anton Pila and I know about it, but what I'm saying, probably I might have not dealt with it in practice. Yeah.
So these are the areas you'll be asked to
Yeah.
to deal with. What is estoppel? Doctrine of estoppel.
I think the principle of estoppel is where somebody has done something and you want to run away from what he has done, then he is stopped from running away from it. And I think one of my writings, which I have brought, is about a matter where the parties entered into an agreement, and in that agreement, it was to supply of oil. And
The first sample writing.
yeah, it's one of my sample writing. And I want to give what an estoppel is from the perspective of that judgment, which I did in Mombasa. It's only civil judgment I've annexed to my application, and is a party. They entered into a contract for the supply of oil products,
Okay.
but the party was supplying was not.
What did you want to stop? What did you stop them from doing?
What I did is the defendant was now he was supplied with oil, and he was now and he had even done part payment, and he was running away saying that I cannot pay because this contract is illegal because we are not licensed to deal with oil products.
Okay.
And I told them because of your conduct, you are stopped from running away from the obligation they have under that contract.
Thank you. And finally, issue estoppel. What is issue estoppel?
Issue estoppel, I think, is where, well, that one, Your Lordship, I think I might need to go and look at it. But I have an idea what estoppel is.
Okay.
Yes.
So issue estoppel, you look at the process of pleadings. Okay.
Yes.
Thank you.
Thank
All
you.
the best.
Thank you very much.
Thank you, Chair. Good afternoon once again, Your
Good
Honor.
afternoon, Commissioner.
Okay, thank you for highlighting to the Commission the challenges that are at Makadara Law Court, because we have been trying to see what can be done to address the issues of brokers, masqueraders, and general access to justice, because the less fortunate also have a voice when it comes to access to justice. What did you do when you are the head of station there in terms of engaging the community members? You have rightfully stated that majority of the users there are from the informal settlement. So what did you do to engage them, to let them understand the challenges that are at Makadara? That is one. And number two, what did you do to ensure that the bail and bond policy and the sentencing guidelines are implemented within all the courts that were under you or operating within Makadara law courts?
Okay. Well, first, I'll start by saying that when I went to Makandara, one of the things I did is I engaged the stakeholders, the court users, and in our court users, we had civil society. There's a group called Korogocho, I can't remember the name, but they used to be very active members of court users committee. We engaged, there's Wangu Kanja, they are also members of the court users committee, and we engaged them to see how we can deal with the vulnerable in terms of assessing justice at Makandara law courts. And we managed to come up with a framework of how we were doing things at Makandara law courts.
So maybe in just summary, what did the framework entail, and how did the members of the community know
What
the
we
contents
did-
of the
What
framework?
we did, we came up with strategies of like, you see, like as I've said, when I went there, it was just, we were transiting from COVID. We were just coming now to the
So
normalization.
I just want the response,
Yeah.
Your Honor, sorry, because
Yeah,
of time.
yeah.
Yeah, what exactly the contents of the framework? You say there's a framework,
Yeah.
yet we still have cases of the vulnerable being denied bail or high bail terms.
Yeah.
Yes.
One of the things we did, we agreed with the probation officers and even the stakeholders, like the members of the civil society, that we come up with the lenient bond terms, looking at, of course, the nature of the offense and all that, and we were able to do that. We would even ask for pre-bail reports so that we see whether this person is eligible even for free bond. So those are some of the things we came up with.
But those are things that are there. Those are, I thought you have new and fresh ideas,
And
because
as I also engaged with my colleagues, and we agreed that we just give lenient bonds, knowing that the people there, they have, as I've said, they are just the poor of the poorest in the city, I would say that. And I would even give bonds of 1,000 shillings, 2,000 shillings, but surprising the commissioner. You'll be surprised that you give somebody a bond of 2,000 shillings, cash bail, and they are not even able to pay. So it becomes...
I don't know whether you're listening to my question, Your Honor. Yes, you have said the issue, the challenges, and everything, but the expectation with this bail and bond policy, the sentencing guidelines, the framework under the CUC, you are allowed to come up with specific issues. I know there are places where if it's issue of community land, they come up with issues that would then address community land issues within their space. So for you, the lenient bond terms you have said did not work, so and
Actually,
still does not work.
Through the engagement of the stakeholders, and especially the Office of the Director of Public Prosecution, we came up with we improved on the plea bargain. We would encourage people to plea bargain, because it's only that.
Okay, plea bargaining,
Yeah, plea bargain.
any other issue?
We also had the issue of diversion.
Oh,
And
okay.
actually, there's one case which was done, although it was not done when I was there, but there was two communities which were fighting over a land at this Burj community. And actually through diversion, it was, the matter was moved from the court, and it was settled by the community themselves in a form of what I would call alternative justice system.
Okay,
Yes.
thanks. And what is your understanding of structural interdicts?
Thank you, Commissioner. My understanding of structural interdicts is that it is where the violator of the rights is called upon to remedy those rights, the violation, under the supervision of the court. Yes.
There is the argument that the court is funked as officials. Once the order is granted, the court has no powers.
I think
To supervise.
from the decisions, which and especially the decision of Mitebel versus Kenya Airports Authority, the court was very clear that, and especially I would refer to what Honorable Justice Gungi said. Lady Justice Gungi said in a judgment in the High Court that I think the doctrine of structural interdicts is as an exception to the law of the doctrine of functors official.
Yeah. Okay. Thank you, and all the best. Thank you, Chair.
Thank you very much.
Thank you, Honorable Chair. Honorable Kyambia. We have a report from the Directorate of Performance Management.
Yes.
Did you get a copy of it?
It was sent to me.
It was sent to you.
Yeah. And actually, it was I had to, because I'd asked for the report earlier when I was shortlisted for preparation of the interview.
Yes.
I was sent from the directorate, and I had to ask again, and it was sent yesterday to confirm whether what was sent is what is with the commission.
All right.
Yes.
And from this report, your performance is extremely good, and it agrees with all that you have said to us in the course of this interview. Because in terms of productivity in the various courts that you've been to, from 1st of July 2023 and 31st of December 2023, the number of cases handled is 333 cases. The court productivity during the same period is 190 cases. And in terms of the percentage, your percentage is 35% out of the expected 20%, which means you work extremely hard. And your performance compared to court performance is 175%. Again, that is extremely commendable, and you're doing a very good job. I dare say that you are an asset to the institution of the judiciary. Apart from just being a hard worker, I think you also come out as a very forthright officer. So I have no question, but keep up the good work.
Thank you very much, Your Ladyship.
Thank you.
Thank you. Thank you, Chair. I have only one question for you, Your Honor. How would you handle a situation where a witness or a party in a case is being uncooperative or disrespectful?
Well, in such a scenario, and I would say when a witness becomes uncooperative, there are ways of dealing with that. And one of the ways is you can warn the witness at the first instance that he should cooperate with the court, and if need be, you may need even to go further and impose sanctions in terms of you can even remand the witness if he is disrespectful to court, because actually if he becomes disrespectful to the court, it might be to an extent of his contemptuous to the court. I've said as I've said, we warn first, and if he proceeds and he continues to be disruptive to the court proceedings, that one may amount to contempt of the court, and there is a way of punishing people who are in the contempt of court on the face of the court. Yes. Thank you.
Thank you very much, Chair. Yes. Article 47 of the Constitution makes provisions in respect to fair administrative actions. What are the rights of a person in respect to an administrative action? You can be as specific as possible.
Thank you, Commissioner. I think under the Administrative Actions Act, a person who's is being, I mean, if it comes to across that act, or rather, the act calls for expeditious, efficient, lawful, reasonable resolution of a particular act. Yes.
And procedurally fair.
And yes, of course, procedurally fair. Yes.
Yeah, I wanted you to be quite specific. Fine. So what legislation has been enacted by Parliament to operationalize Article 47?
We have the Administrative Actions Act, I think.
Yeah.
Yes. Then there is, I think there are two. The other one is escaping my mind because it also starts with the word administrative. Yes.
Okay, thank you.
Thank you very much.
Good afternoon, Mheshimiwa, once more.
Good afternoon to you, Commissioner.
I have seen you have worked as a team leader
Yes.
in the past, tasked with the responsibility of managing a team. And as you know, JSC is very keen on ensuring well-being of all those that work for the institution, and especially mental wellness, because in the absence of this, then we will not be able to achieve or deliver on our mandate. What are some of the measures you put in place to protect the team that is working under you against burnout?
Okay, well, some of the measures we have put, and I would say is, one, we usually have our meetings, and in our meetings, we encourage people to not to, overwork themselves. Yes. Secondly, like for instance, like where I am now in Embu, we have come up with an activity within the court where we have people who come, and especially even after work, to come and because our court is very big. I think Commissioner, you are there and you saw it for yourself. We have set aside some of the space to have somebody who come and trains us, in terms of exercise and all that. And secondly, we also again in retreats where we go and sit down, again ourselves, and basically get out of the work and put our minds out of the work and see so that we can rejuvenate ourselves. Yes.
What in the first place causes this burnout?
One of the reasons why there is burnout is there are people who would want to overwork themselves, and that is something which we have tried to discourage. Don't overwork yourself. The most important thing is let us meet our expectations as an institution, as a court, but let us not overwork ourselves, because overworking ourselves actually it will become counterproductive at the end of it all.
Mheshimiwa, we have one very low-hanging fruit, that is the provision of leave, annual leave.
Yes.
What is your role in managing that process as a leader?
Actually, as a head of station, I approve leaves for my colleagues and the staff, and I've ensured that everybody must take their leave, because actually it is an entitlement, and it's one of the way of when people can now just go and have a rest, because you can't work without going on leave. Actually, even people will ask, why don't you go on leave?
But I'm surprised you're not mentioning it as one of the ways to protect your
Actually, it is only that, when you are here, some things will escape. Yeah.
Okay, thank you, and I wish you the best.
Thank you, Commissioner. Sorry?
Thank you, Mheshimiwa.
Thank you.
Thank you, Commissioners. This has been an engaging session with Honorable Kyambia. Thank you. We will get in touch with you when we complete the process. But just to encourage you to continue working hard.
Thank you.
I think we've been encouraging candidates that you have to continue working hard.
Thank you.
When we complete the process, we will get in touch with you. But on behalf of the commissioners, I wish you well and send you with greetings to the people of to Embu, and I think they received me very well as well.
Thank you.
Yes, but if you have a question, you can also ask us.
Okay, thank you, Honorable Commissioners. I don't have a question, But mine is just to thank the Commission first for shortlisting me for this interview out of the 305 applicants, and secondly, for giving me an opportunity to come and express myself and prove to the Commission, become a judge of the High Court. And thank you very much. I also wish to take this opportunity to wish the Commission well as you are going and as you continue. I know it is a difficult, exercise, but I know God is going to guide all of you to successfully carry out this exercise. Thank you.
Thank you, and have a very good day. Thank you for those kind words. Have a very good day. You are free now to leave.
Okay,
All
thank
the
you.
best.
Okay. Can I leave with the notebook? And the water. Okay, thank you very much.